Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to circle back now on some of these Bruin response bills, in particular, all of these sensitive places that were passed for the Supreme Court having the audacity to actually uphold the Second Amendment. Now, the two most egregious offenders in that entire thing were California and New York, because they essentially passed bills that made, well, their entire state now one gigantic sensitive place. Now, as it relates to New York, you may recall that upon appeal, the Second Circuit, well, they had no problem upholding just about that entire law, and candidly, Second Circuit has never really found a piece of civilian disarmament legislation that they didn't absolutely adore. Well, now that case is on petition to the United States Supreme Court, and the folks in New York are going to get a little help from the folks in California, but there is a much bigger issue in here, and it's an issue that's brought out in an amicus brief that we're going to talk about today, a really well done amicus brief, by the way. So today, let's geek out for a little bit and let's talk about how this New York case will impact the entire country. Okay, so the case we're talking about today is Antonyuk v. James. It is a challenge to the sensitive places that were set forth in the Concealed Carry Improvement Act, aka the Bruin response bill that was passed by the New York State Legislature as a big gigantic middle finger to the United States Supreme Court after they ruled in the Bruin opinion. Now, want to thank, and if you're not following this guy on Twitter, you're missing out. Costas Moros, right there, follow him on Twitter. Listen, I really go to Twitter for one of two things. I get immensely educated by some people. I get immensely entertained by others. He happens to do both. If you care about your Second Amendment rights and you're out there in the exosphere, Twittersphere, whatever the hell we're calling it this week, you really should be following him. Now, there are a lot of plaintiffs actually on this particular suit. There are a lot of people who I should say have joined California here in applying for this amicus brief, which again, as we know, is a friend of the court. So this is people jumping in on behalf of the petitioner saying, yes, Supreme Court, you really should take this case. And oh, by the way, when you do take it, you should also rule in their favor. All of the people signed on to this amicus include Second Amendment Law Center, California Rifle and Pistol Association, Inc., Gun Owners of California, Federal Firearms Licensees of Illinois, Second Amendment Defense and Education Coalition, and Operation Blazing Sword, Pink Pistols. So kudos to everybody who contributed to this amicus brief. I've had an opportunity to read it. We're going through it because I really like everything about it, but there's an important part towards the end of the brief that we're going to really geek out today. Now, I said to you, I really like this brief. I really like any brief that is concise, gets right to the point, explains the law in clear, concise language, because then when I geek out on it, it's very easy for me to turn around and explain it to you so that all of you can understand. But you know what I like even more than that is a brief that does all of that and also happens to troll the other side. That is really cool. And, well, that's what this brief does as well. Let me give you an example. It is unfortunate that the court's intervention is needed again so soon after Bruin was decided in order to vindicate the fundamental right to keep and bear arms in a handful of recalcitrant states. In most states, the Second Amendment right to carry a firearm for self-defense was already well respected even before the court mandated that the remaining states end their unconstitutional schemes aimed at preventing regular citizens from exercising that right. Bruin should have settled at least that issue definitively, and when applied in good faith, it did. But then they also point out, American history teaches us, however, that when state and local governments are forced to comply with Supreme Court rulings they disfavor, provincial defiance must be promptly quashed before it becomes the sort of ingrained custom, habit, or practice that grew out of Plessy v. Ferguson. You gotta love a case that can cite, in good faith, the Plessy v. Ferguson. Now, of course, all of the amicus party here point out that, hey, listen, through California Senate Bill 2, we are abundantly aware of what's going on in New York because we are suffering from the same thing. And as we know, there's already been a bunch of very well-drafted challenges to California Senate Bill 2. And so some of those arguments are obviously repeated here because there is only so many ways that you can skin a cat. If left unchecked, the Second Circuit's flawed decision will embolden other circuits to ignore Bruin and uphold the broad carry bans of other states. And this is one of the big issues that the amicus party points out here. It's like, you know, we're not really having these issues like in the Fifth Circuit because, well, they comprise states that actually allow their citizens to live like Americans. And so we're not seeing a lot of these challenges percolate to the top of these circuits. However, when we go out to circuits like the Seventh Circuit, the Ninth Circuit, and the Second Circuit and stuff like that, well, we see quite the opposite. And we see a lot of these state legislatures very emboldened in these particular districts to just go ahead and pass whatever law they want because they know it's likely going to be upheld. And what that's going to lead to is this horrific stratification, if you would, of our Second Amendment laws, where you will literally have some states where, yes, everyone gets to live free, actually like Americans, and you're going to have other states that will resemble, you know, like 1964 East Germany. And listen, right now, this is almost turning into kind of like a runaway train, the open defiance of Bruin. So what the amicus party points out is, Supreme Court, you got to step in right now and do something about it, like now. The court should step in now and disabuse lower courts of the notion that they are free to narrow Bruin on their own terms before such treatment becomes baked into the Second Amendment jurisprudence of the circuit courts. But this is what I really want to focus on, okay? And I think this is a really, really powerful part of the brief. And I will tell you that it kind of forced me to correct how I'm going to talk about Bruin as well. Because what the amicus party is pointing out here is listen, even the courts that are sometimes getting it right are actually misapplying Bruin. They're actually creating additional steps that when you really go back and look at it are not even supposed to be there. And so what's going on here is they are establishing a first part of the test where the proponent of the challenge, the petitioner, the plaintiff, has to first establish that the conduct or the instrument that's being described actually falls under the purview of the plain text of the Second Amendment. But that's an unconstitutional burden shifting, and it's also contrary to the very clear holdings of Heller, which says that the Second Amendment covers all bearable arms, even those that were not in existence at the time that the Second Amendment was ratified. Anything that can be placed in hand and used to defend either offensively or defensively in the time of conflict constitutes an arm. Now, some arms can still be banned, however, it must meet the constitutional test. So what the amicus parties are saying here, and they're dead right, is there really should be this presumption that the activity is covered by the Second Amendment, and those that are trying to uphold the law, the first threshold they have to get to is to try to establish that it is not covered. And if they can't do that, they're going to have to establish the legitimacy of the law through a historical analog. Because the Second Circuit fundamentally misunderstood the approach Bruin requires, this case presents an opportunity for this court to clarify the correct way to apply Bruin's text, history, and tradition analysis. While it did not ultimately affect the result of this particular case, this error affects many post-Bruen rulings in far more egregious ways. Indeed, courts have seized upon this manufactured first step to relieve the government of its burden under the historical test altogether. Don't believe it? We'll consider this example as the amicus party points out here. Take the Seventh Circuit's ruling in Bevis v. City of Naperville, for instance. The court in that case astonishingly held that a ban on extremely popular rifles and magazines does not even implicate the Second Amendment because the semi-automatic AR-15 is not a protected arm because it is apparently indistinguishable from the fully automatic M16. In fact, according to the Seventh Circuit's reasoning in Bevis, no weapon used by the military is an arm. And despite this court saying repeatedly in Bruin that the burden is on the government, Bevis places the burden on plaintiffs to prove that the banned firearms are arms that ordinary people would keep at home for the purposes of self-defense. Think about the ludicrous nature of that. We have to establish that the arms in question are actually arms first? That, of course, is all contrived nonsense. This court has been abundantly clear that the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. Of course, citing to Heller. And then they continue with, in fact, even M16s meet the definition of arm because they are weapons of offense. That does not mean that such weapons cannot be regulated or even banned if our historical tradition supports it. But courts should not be short-circuiting Bruin with a made-up first step to help the government dodge the rigors of historical scrutiny. So think about it. Is what they have is an opportunity to say, I know you bring in a Second Amendment challenge, but we're going to find right now that the Second Amendment does not even apply here. Now think about that if you started making, free speech challenges. Well, we know that this is a First Amendment challenge, but we're just going to make a finding that the First Amendment doesn't apply here, so case dismissed. As the amicus party points out, to be sure for there to be a viable Second Amendment challenge, the right to keep and bear arms must at least be implicated. Just as First Amendment free speech case must involve speech, so too must a Second Amendment case involve a peaceable use or ownership of arms. But this should not be no more than a qualifier, not an independent step requiring an in-depth analysis. Further, implicating the Second Amendment may be direct or indirect because the Second Amendment also protects attendant rights that make the underlying right to keep and bear arms meaningful. Kudos to everybody on this amicus brief. Very well drafted. And that last section that we outlined, incredibly important, America. That's why this case will be so huge. Because right now, in open defiance of Bruin, we are seeing courts carve out this imaginary first step to what is not supposed to be anything more than a one-step test. And this needs to be reined in right now before this does become, in fact, ingrained into our lower circuit courts. The case, once again, is Antonyuk v. James. We'll link up this amicus brief down below so that you guys can geek out on it for yourself. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is also down there in the description box. And then finally, let's remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.